Hello, my name is Michelle Hunt, and this is my case study for special education for administrators. Okay, so a quick summary on the case study. This is at Nottingham High School, which was built in 1950. Upgrades to the building have been made to meet federal ADA requirements, but a fourth of the school had not been updated due to lack of funds. Miguel Hernandez is a student at Nottingham. He is a quarterback and was injured during a home football game. He was tackled by a player from the opposing team, and Miguel was transferred by ambulance to the hospital. The injury left Miguel paralyzed from the waist down and unable to walk. After months of rehabilitation, Miguel was ready to return to school. Miguel's parents requested a meeting with Miss Gussman about his return to school. Miss Gussman requested a doctor's release for Miguel's return. When he returned to school, the principal, held an assembly and gave Miguel an award for his contribution to the football team. During his first period class, Miguel was informed by Miss Gussman that she wanted to meet. During that meeting, she told him that he was moved from his third period biology class due to wheelchair accessibility. He was moved to a science class that would meet his requirement for graduation. Mrs. Hernandez, Miguel's mom, did contact the office the next day to set up a meeting with myself. During that meeting, she requested that Miguel be placed back into his biology class due to the university that he will be attending and the requirement of this class. Mr. Hernandez came in late and brought a lawyer named Howard Carey. Mr. Carey stated that denying his client the right to a free and appropriate education, Miguel needs to specific accommodations that allows him access to the biology class and others as needed. Okay, so here are some of the legal issues. After doing some research, the medical note is not required under ADA, but would be required by a 504 plan. There hasn't been a 504 plan, so I am kind of questioning the reasoning for Mrs. Gussman to have a release for him to come back. Removing Miguel and not moving the whole class would be a breach of the ADA requirements. Districts are not required to make changes to every part of an existing facility that is built after June of 1977 if funds are the reasoning or if there isn't a way to make the building accessible, but they do require the district to make every class activity or sporting event or sports activity accessible to every student. So schools still must provide students with disabilities access to that program or activity in question, access to programs operated by a school and older facilities that are totally or partially inaccessible may, in some instances, be provided through a structural change or a relocation of that program. Public schools, so I did do some research on the liability to Miguel's injury. There are lots of circumstances that could make others liable or not, but looking at the case study from Herman and Herman Law Firm, public schools are shielded from liability for sports-related injuries. This is because they are regarded as a government agency, as well as there is most likely a release, which was not told, but there was most likely a release filed with the district for him to play the sport. It didn't look like the player that tackled him did so in a malicious way, and it looked like medical care was given at an appropriate time. So there would not be any liability to anyone involved due to the injury. Some ethical things that I saw questioned for me, removing, which is also a legal issue, but also an ethical thing, removing Miguel from his biology class. I questioned the assembly that they held. I'm not sure, it didn't tell us if his parents were contacted, if he to see if they were okay with this assembly, how he was feeling about his return. Just some things I'm not sure. The award is great, but I'm not sure how he was feeling, so it didn't tell us if he was contacted, or his family was contacted about that assembly. The 2 weeks before he could return, it did say in the case study that his doctor had and his family had agreed that it was okay for him to return, but then Ms. Gussman required the note, which isn't required unless he's on a 504 plan, or if it was on IDA, which he didn't qualify for IDA because his injury didn't affect his learning, his ability to learn. So that 2-week time frame seems extremely excessive to me. There was not a breach of any contract that I saw. The removal from class could be seen as discriminatory, also due to his lack of accessibility into that room. And then I did not see any harassment. So to synthesize the case study, Miguel Hernandez was paralyzed during a school football game, and upon returning to school was removed from his biology class due to accessibility. This class is needed for college. So here are some of the facts that I synthesized. The people involved are Miguel Hernandez, Miguel's parents, Howard Carey, the lawyer, the principal, Miss Gusman, the counselor, player who tackled Miguel, and then the principal's secretary. The place was at Nottingham High School football field, the counselor's office, biology class, the principal's office, and then the updated facility. Any programs involved were Nottingham Public High School, his biology class, the college preparatory class of the biology that he was in, as well as ADA or a 504 plan. Okay. So to review and prioritize the information, the outcome of this decision could have damaging consequences for all stakeholders involved. The superintendent and the school board need to be consulted on this matter. Some missing information that I did find is the date of the alterations made to the school building. If parents of Miguel were consulted on the celebration of Miguel's return, what was the reasoning for the doctor's release for him to return, and then why did it take an additional 2 weeks before he could return? Okay. Okay, so options and possible consequences. Option 1 would be to fire the counselor, apologize to the family, reinstate Miguel into his class and move the class to an area that is accessible to him, contact the superintendent to inform him or her of the situation, and then talk with the staff about how to handle this situation moving forward. Option 2 would be to talk with the counselor about why pulling Miguel is a breach of his rights under ADA and 504. Reinstate Miguel into his class and move the class to an area that is accessible to Miguel. Create a 504 plan for Miguel. Contact the superintendent to inform him or her of the situation. Consult with the district's attorney. Ask for next steps on how to proceed with the lawyer to make sure that we're doing everything lawful. Professional learning for staff on ADA and 504 requirements. And then I would want to meet with Miguel's family and the superintendent together. Okay, so the options or the evaluation of option 1, the pros would be that you would apologize for the situation. 2 would be staff knows that the situation is not something that I would tolerate in the future. Miguel will get to take classes needed for the university he's attending. We would be abiding by ADA and 504 laws. All stakeholders would be informed. The cons would be that we would be admitting guilt. Staff would not be properly trained on best practices, and not all stakeholders had been informed. So option 2. So option 2. Whoop. Sorry. Okay, so option 2. The pros would be Miss Gusman understands why she cannot pull students from classes. Staff will be properly trained on ADA and 504 laws and policies. All stakeholders will be informed. I would have followed all laws and regulations moving forward. Miguel would take the class that is needed for his university. The cons would be I would admit that I have not trained my staff properly. There would be no formal apology to the family, and it may take longer because of the steps involved to inform all stakeholders. Okay, so the choosing of the best option, I would choose option 2. All stakeholders have been notified. A lawyer has been consulted. Miguel is back in biology class. We would create a 504 plan for Miguel. Staff would be trained in the correct laws and policies. Ms. Gussman will get to keep her job and be properly trained. There would be no admission of guilt unless directed by the superintendent or the lawyer. And I would meet with Miguel and family. So how I would implement option 2. First, I would immediately move Miguel back into his biology class and move that biology class to somewhere that is accessible to him. I would then inform the superintendent of the situation and contact the district lawyer. As well, I would set up a meeting with both of them to discuss all this. After meeting with them, I would inform Miguel's parents of his return to class. I would set up a meeting to start Miguel with a 504 plan with his parents. I would set up a meeting with Ms. Gussman to go over the reasons of why Miguel cannot be pulled from class. I would contact a trainer on ADA and 504 laws to train the staff properly. After talking with the superintendent and lawyer, I would set up a meeting with Miguel's parents and the lawyer if they requested to go over everything and make sure that we have all accommodations and all his needs are being met. Plan B, if this didn't work, I would let the superintendent and the district lawyer take the lead on this because this can be a legal issue. So I would let them be in charge and ask them how I can help and assist to make sure that we are following all those ADA laws and 504 plan policies and laws. Okay, so the standard integration, this assignment correlated standard 3 by allowing me to research and advocate the best support for Miguel, and I created a plan to support Miguel providing the resources he would need to be successful in school. The assignment was critical to my current learning as a future leader. Knowing how to deal with situations like this is essential, and being able to make those informed decisions is very important. When I could think through the steps logically, I realized that the staff at Nottingham had not been appropriately trained, and if they had, this would most likely have not happened. That is at fault of the principal for assuming that there had been training. Also, the principal should have been more involved with the meetings and Miguel's return to school, and this also may have not happened. I enjoyed this assignment. It was a challenging assignment. You had to do a lot of research on ADA laws and 504 policies, then make a decision on what's best for the student, and that fit within ADA parameters. I also thought about how this could have been prevented if the principal had adequately trained his or her staff, and had taken the lead on Miguel's return to school and not leaving it up to the counselor. As a future leader, I will need to consider these things and ensure I follow them. And here is 2 resources that I used. Herman & Herman Law Firm, which had a lot of information on school liability for sporting events. And then I looked at the U.S. Department of Education's website on 504 policies and ADA law.